So in the last week, we actually spoke about 3 different instances when you're buying property where it is necessary for you to actually appoint an attorney to always advise you, because those 3 different sale processes actually comprise of quite a number of legalities, and it's easy for someone who's not well versed within the property industry to actually overlook them. So someone with legal expertise will always point these out for you so that you don't make any mistakes, because we all know mistakes in property come at a very high cost. So we explained that. Now in this week's video, I want us to start a 5-series video. Now in this one, we're going to talk about what the process is of buying a property out of a deceased estate. Now, and then in the other videos, we'll talk about the different types of properties that are owned by different kinds of people or different kinds of institutions, so that you understand the different processes and what they entail, so that you understand some of the legalities and also what to look out for even before you get to the attorney. Because before you get to the attorneys, there's certain things that you also need to ascertain, so that you are covered and so that you understand why certain things are taking longer, why others are taking shorter time. This will make it easier for you to know exactly what you're getting into when you're purchasing a property and what to expect. So let's dive into the content. So for all of those that are new here, let me introduce myself. My name is Yolanda Mnyengeza, and I'm an attorney and a director at Mnyengeza Attorneys. So here today, we're going to talk about the process of buying a property out of a deceased estate and how long this process can take and what you need to look out for, the do's and don'ts. So let's start even before you enter into this kind of transaction, a sales transaction. Let's say you see a house and you like it and you want to buy it. What are the first things that you need to do? The first thing that you need to do is establish whether the person that's selling the property is actually the owner. If they are not the owner, establish whether they have the authority. And this authority normally needs to be written down. If it's an agent, they have to have this written down to say that they have a right to sell that property. And so once you've established that the person that's selling the property is actually the rightful owner, then you can actually move on with the property. Now, in the case of a deceased estate, who would be the owner then? Who would you need to actually speak to know that you're speaking to the right person? Because remember, a deceased estate means that the property that's being sold belonged to someone that's passed away. So who is this person? Now, in a deceased estate, the person that you need to speak to is who we call an executor. An executor is the person that's responsible for administering the deceased estate of the person that's passed away. So that's the person that you need to be speaking to first. But before you get deeper into the conversation, establish, do they have letters of executorship or letters of authority that give them authority to be the executors in this particular estate? If they don't, please emphasize that they do so first before you even go further into the discussion. In fact, at this point, if they don't have letters, I would halt that conversation altogether and advise that they approach the Master of the High Court. Now, if they do have letters of authority, then you can continue with the discussion. The second thing that you want to establish is who are the people that are going to benefit here, because sometimes the executors are not people that will benefit. There's other people here. So who are those people? Get them in the room, speak to them as well. Do they agree to the sale? Are they willing to sign what we call a consent when the process needs to start? If they say yes, then okay, get into this conversation. And the third thing that you want to establish here is their title deed. Where is it? Can we find it? Because in a sale, we need the original title deed for it to continue. If it's non-existent, let's try to make a plan here on how to apply for a new one, because it's going to be needed for the property transaction when it needs to be transferred to your name. Okay? And the fourth thing that we often overlook, and I always emphasize, get a look at the rates. If they own they are responsible for paying rates at the local council, have a look at the rates. What are they looking like? Because here's the thing, before the transfer can happen, those rates need to be cleared. Okay, so sometimes people tend to find out quite later, and when they actually see the rates, it actually tends to delay the whole process, because you find that the rates are quite expensive and those rates need to be cleared by the seller. And if the seller doesn't have money, it means that the process is going to prolong. Okay, so have a look at this. Also have a look at the house. That's the fifth thing. Have a look at the house. If they are offering a certain amount of money, is it reasonable based on what you're seeing here? Is there anything that you need to fix? That's the only way you can literally be able to properly negotiate with the person here. Okay, so majority of the sales, it's not necessary for a property to literally be sold at market value, more especially if it's not in good shape. So you can have a discussion with people, what's the situation? And plus, in a deceased estate, it's always wise to call in an estate agent to come and value the house, because if it's bad, they can actually be able to say, okay, this is the value of this house. And then once you have spoken and established all of these things, you can move on, and we'll talk about the process in a minute. So now that we've established the 5 things that I spoke to, what needs to happen now? What are we looking out for? Okay, so this is what I want you to note, and you would have picked this up in the other video. Now, when you're buying a property out of a deceased estate, it's going to be a much longer process. I'm going to tell you just now why. The reason why, it's because this is a two-way process. We're dealing with a deceased estate which is being administered. We're dealing with the property issue, which needs also to take place. So these 2 things are taking place, you could say simultaneously, but the first, there's a couple of things that need to happen on the aspect of the administration before we can actually move to the sale, which is why when you're buying a property out of a deceased estate, you can expect a few delays. Okay, so what needs to happen? The first thing, since the executor has gotten the letters of authority, then we can have a sit down and talk about the price and how things will be. Now, during that, also the beneficiaries or the heirs need to now sign what we call a consent as well. But before anything can actually move on, there also needs to be an advertisement on the newspaper as required by law, so that creditors of the deceased can come forward. Because before we actually sell this property to someone, we need to be certain that in actual fact there aren't any creditors, or the creditors can be settled, or what the financial situation is. And the financial situation we can only understand once we have heard whether or not there are creditors on this particular estate. Okay, so once the whole estate has been advertised, it normally takes 30 days. Okay, then people can move on. What needs to happen now? The consent of the heirs needs to be established, documents need to be signed, and then consent needs to be requested with the master of the High Court. Now, even though the heirs are going to be the rightful owners of this property, but they are not yet. And so, because this is a deceased estate, the master has to give approval. Now, the master is going to look at whether the creditors came forward or not. If they did come forward, what are their claims? Are they trivial? Can they be settled? What's the situation going to be? Is this estate still, is it not solved? Is it solvent? Or what's the situation? And then the master can give the consent. Now, normally that process also, you can say it takes about a month. So already you've spent 2.5 months trying to deal with the master. We're not even close to the sale issue. This is what causes a delay when you're buying property out of a deceased estate. And so once the master has given the go-ahead, then the process of actually lodging the documents from the deeds office or to the deeds office can now start. Now payment can be effected. But who are you effecting the payment to? You're giving it to the attorney. People, stop giving sellers money cash. Stop sending money via EFT to sellers. You send it to an attorney. The attorney places it in their trust account, and then they will pay a portion according to the contract to the seller. And then the rest of the money is going to be paid after the property has been legally registered in your name. So stop giving people money cash. People lose a lot of money doing these things. Sometimes people do it to secure the property because, for instance, the person says, you know what, if you don't secure the property, I'll sell it to someone else. Let them sell it rather than you lose money. Okay, if someone is genuine and they want to sell this property and they can see that you want to as well, they will do whatever it is that they can for us to get to this stage so that payment can be made. And I mean, in the interim, if you want to, That's if you want to. You can place this money with an attorney to show that you're serious about this transaction, but giving it to them, it's not a good idea. Okay? So that, in a nutshell, is the process of actually buying a property out of a deceased estate. Now, let's recap and also talk about the most important documents that you have to make sure are there. The rest of the documents the attorney is going to gather, him or herself, but these are the documents that you need to see in order for the sale to go through. Number one, the title deed, the original title deed. Number two, the letters of executorship or letters of authority. Number three, the consent from the heirs that they are also agreeing to the sale. Number four, their identity documents, all of them, and also your identity documents, the contract, the consent from the master, and then everything else will be taken care of by the attorney. If there is no consent, be careful, don't pay yet. Just get the consent first and then go ahead. If there's no title deed, emphasize they need to get this. And like I said initially, if the executor does not have letters of executorship, don't get into that situation. Tell them to get the letters first, and then you can have a discussion with him or her as well as the heirs so that you are on one page. So this is literally how things will go if you're buying a property that belongs to a deceased estate. Make sure that you take cognizance of the things that we spoke about, the do's and don'ts, the most important requirements, and also don't forget your attorney to be with you as the buyer. If you have the contract being presented to you, you've got an opportunity to go to your own attorney to say, have a look at it for me, and then come back if you need to the sellers to negotiate, or else sign the contract so everything can go ahead. Well, I hope this conversation and this content was helpful. If it is, please don't forget, like, share it to other people, and also come back, because next time we're going to do part 2 of the series, and we're going to talk about the process of buying a property when the minor is the owner. My name is Yolanda Mnyengeza, and I'm an attorney and a director at Mnyengeza Attorneys. Let's see you next time when we talk about something useful to you.